RTI Limited against MUR Shipping BV.
This judgment will be handed down by Lord Hamlin.
Force majeure clauses relieve a party from its obligation to perform under a contract on the occurrence of a specified event or state of affairs. Such clauses commonly provide, expressly or impliedly, that the clause cannot be relied upon if the effects of what would otherwise be a force majeure event could be avoided by the exercise of reasonable endeavours by the party affected. The central issue which arises on this appeal is whether the exercise of reasonable endeavours may require the party affected, if it is to be entitled to rely on the clause, to accept an offer of non-contractual performance from the other party in order to overcome the effects of the event or state of affairs. The force majeure clause in issue was contained in a contract of affreightment by which the appellant, MUR, the ship owner, agreed to make monthly shipments of bauxite from Conakry in Guinea to Dneprobugksy in Ukraine between July 2016 and June 2018. The respondent, RTI, agreed to make monthly freight payments to MUR in US dollars. Clause 36 of the contract was a force majeure clause. Clause 36.3d was a reasonable endeavours proviso. It stipulated that the specified event would only be a force majeure event if, quote, it cannot be overcome by reasonable endeavours from the party affected. On the 6th of April 2018, RTI's parent company was sanctioned by the US government. The parties now agree that this was highly likely to create difficulties in RTI making timely contractual payments in US dollars. MUR claimed that this constituted a force majeure event and suspended the shipments, relying on the force majeure clause. RTI disputed this and offered first to make payments to MUR in euros, which could then be converted into US dollars by MUR's bank on receipt, and secondly, to indemnify MUR for any loss it suffered as a result. MUR rejected RTI's offer. RTI commenced arbitration against MUR. The arbitrators upheld RTI's case, but MUR could not rely on the clause because, in rejecting RTI's offer, it had not satisfied the reasonable endeavours proviso, and it awarded damages to RTI for breach of contract. MUR appealed to the High Court. Mr. Justice Jacobs allowed MUR's appeal on the basis that the reasonable endeavours proviso did not require MUR to accept an offer of non-contractual performance. RTI appealed to the Court of Appeal, which allowed the appeal by a majority, Lord Justices Mayles and Newey, with Lord Justice Arnold dissenting. The majority held that the event could have been, quote, overcome by accepting RTI's offer, as this would have achieved the same result and would have involved no detriment to MUR. It therefore would have constituted reasonable endeavours. MUR now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal. Lord Burrows and I give the judgment with which the other justices agree. Reasonable endeavours provisos are commonly found in force majeure clauses, either expressly or impliedly, and in materially similar terms to the clause in this case. It follows that the issue raised is one of general application, which should be addressed as a matter of principle. There are several reasons of principle which support MUR's case. First, force majeure clauses in general, and reasonable endeavours provisions in particular, concern the causal effects of impediments to contractual performance. The party affected must be able to show that the force majeure event caused the failure to perform. Contractual performance means performance of the contract according to its terms. Failure to perform means failing to perform in accordance with those terms. The causal question is to be addressed by reference to the parameters of the contract. Secondly, the principle of freedom of contract includes the freedom not to contract. This extends to the freedom not to accept non-contractual performance. Thirdly, clear words are needed to forego valuable contractual rights. Under the contract, MUR had an undoubted right to insist on payment in US dollars and to refuse payment in any other currency. Fourthly, certainty and predictability are of particular importance in the context of English commercial law. MUR's case is straightforward. Absent clear wording, a reasonable endeavours proviso does not require acceptance of an offer of non-contractual performance. The focus of and limits to the reasonable endeavours inquiry are clear. They are provided by the contract. By contrast, RTI's case is not anchored to the contract. It requires potentially complex and contentious inquiries into whether the acceptance of non-contractual performance would first involve no detriment or other prejudice to the party seeking to invoke force majeure, and secondly, achieve the same result as performance of the contractual obligation in question. The authorities relied on by MUR also provide strong support for its case, in particular Bullman and Dixon and Fenwick, and the Vancouver Strikes case. In these cases, it was held that impediments to performance could be relied upon, even though they could have been avoided by the exercise of a contractual option by the party affected. In this case, there was no option for MUR to accept payment in euros. Had there been, these cases indicate that MUR would still have been entitled not to exercise that option and to insist on payment in dollars. The various cases relied upon by RTI are distinguishable and do not assist. The Supreme Court therefore allows MUR's appeal.
The court will now adjourn.